The jury in the Forgetful grandmother manslaughter case has a verdict in their deliberation over the fate of Tracey Nix. Let's go in live.
Ready, Judge?
All rise, yes.
All rise.
All right, everyone have a seat. We're back on the record for State of Florida versus Tracey Nix, CF 22-289. Members of the jury, did y'all reach a verdict? Who's if my foreperson would raise their hand and hand the verdict to the bailiff. All right, defense, please rise. Mrs. Nix, please rise. All right, we're going to go ahead and publish the verdict.
In the Circuit Court of the 10th Judicial Circuit of Florida, in and for Hardy County, State of Florida versus Tracey Howard Nix, case number CF 22-000-A000-XXW, verdict form. We, the jury, find as follows as to count one of the charge. The defendant, Tracey Howard Nix, is not guilty. We, the jury, find as follows as to count two of the charge. The defendant, Tracey Howard Nix, is guilty of leaving a child in a motor vehicle in excess of 15 minutes, causing great bodily harm.
Don't read anymore.
Yes, sir.
All right, thank you. Mr. Fletcher, do you wish the jury to be polled?
No, Your Honor.
State, do you wish the jury to be polled?
No, Your Honor.
I'm going to release the jury.
No objection.
All right, all rise. Members of the jury, I want to give you your final instructions. Hold on one second. Ladies and gentlemen, I wish to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors, such as yourself. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from the attorneys, and elsewhere. It will be up to you to decide whether to preserve your privacy as a juror. I want to thank you on behalf of the citizens of Hardy County and Polk County for spending your time with us. Thank you very much for your time and consideration. You may be excused.
Even note.
All right, all. Once they leave, have a seat, and I'll have the defendant proceed to the podium with their attorney. Okay. Let's hear. Brother. Okay. Ms. Nix, stand next to your attorney, Mr. Fletcher. Everyone's got a seat. Mr. Fletcher, Tracey Nix, having been found guilty by a jury as to the charge of leaving the child unattended in the vehicle for more than 15 minutes, contained in case number CF 22-289, I now find you to be guilty of the offense. State, what's your position on remand or bond?
Your Honor, she's been convicted. At this point, I would ask that she be taken into custody.
Defense, position on remand or bond?
Your Honor, I request that she be allowed to be out on bond until we have a sentencing hearing. Will be requesting a less than guideline sentence. I will request, based on my experts, that you partially heard that her sentence be below guidelines. I have also had my office contact the bail bondsman. He is willing to remain on the bond. I can tell you that as an officer of the court. There's plenty of time to incarcerate her. I do need her also to be able to prepare for sentencing.
All right, state anything further?
And further, Judge, she's been on pretrial release for over 2 years. There hadn't been a second's problem with her. She's been to every court appearance that we've had, and I see no reason to remand her at this time.
State anything further?
No, the state stands by its previous position.
All right, a sentencing date of April 3rd at 8:30 a.m. Does that work with state?
We will make it work.
Defense, does that work with defense?
Same as the state, will make it work.
All right. At this point in time, based upon the jury verdict of guilty, I'm remanding you into custody, Ms. Nix. You are to be the sheriff pending the pre-sentence investigation report by the Florida Parole and Probation Commission. Your bond is hereby revoked. You will be held at no bond. I hereby order the Florida Parole and Probation Commission to prepare a pre-sentence investigation report upon the defendant and furnish same to the court as soon as practicable. You will appear April 3rd, 2025 in the Hardy County Courthouse at 8:30 a.m. I've set aside a full day for the sentencing. I ask the defense and the state to be prepared to present their arguments and testimony that they feel is appropriate to have this court sentence Ms. Nix in accordance with this verdict. Anything further, state?
Nothing further, Your Honor.
Anything further, defense?
There you go.
All right, all rise. I'm going to get off the bench.
Wow, it is dramatic to see a grandmother handcuffed in a courtroom and then led out. But what the jury really said was that not guilty on the top count. It took them just over 2 hours to come back with not guilty of aggravated manslaughter. She would have faced up to 30 years behind bars if she had been found guilty of that. What she did get found guilty of was a misdemeanor. Second-degree misdemeanor of leaving a child in a car. When you look at the Florida statute, that's under the traffic laws, like where you would have someone who maybe drank and drove or didn't wear a seatbelt. And from what I can gather from the statute, the max penalty, and we'll get further clarification from the attorneys, we'll see if they'll talk to us after this, but up to 60 days behind bars would be the amount that she could get. But you see they're remanded into custody. We see that reaction from the family, from the parents of this little girl who was left in that car and died in that extreme heat. Let's bring into the discussion those who are standing by just to react to this verdict, this very emotional trial for everyone who's been watching and everyone who's touched by it. We have criminal defense attorney Sam Bassett, who is joining us, and also in studio we have field reporter Cody Thomas, who's with us. Cody, let me start with you and get your reaction to this verdict.
Julia, I don't know if I fully agree with this verdict. I mean, there's a question of intentionality here, of course, whether she meant to do it or she didn't. I don't think she meant to do it, but at the end of the day, there's still an infant that is dead in your car under your watch, let alone this is the second grandchild in less than a year span of time that has died under your watch. 60 days just doesn't seem like enough time for me. That's an incredible responsibility. And the way I look at it, it's her daughter's child. Of course, it's not her own personal child, but I look at it as if I were to drive your car for an hour, I'm driving 10 and 2, I'm going the speed limit, I'm taking care of every precaution because it's yours. It's not necessarily mine. It seems like, especially after the first child died wandering off in that pond in 2021, that you would have high alert. You'd be, every bell and whistle would be buzzing off, every alarm, you'd be locked in on making sure that doesn't happen again. So I don't necessarily agree with this, but 60 days, I guess that's something.
No, we'll see. Again, that's in looking at the statute. We will see what the attorneys say, and sometimes guidelines can be different, especially since we have a death here. Let's bring in a criminal defense attorney, Sam Bassett, who's with us. Sam, what do you think about this verdict and the fact that, to Cody's point, this jury did not hear about that pond incident where her other grandchild died?
Well, I think if they had heard about the other incident, it might have made a difference. But despite that, this is a huge victory for the defense, in my opinion, to avoid a felony conviction. And I think the jury paid close attention to the jury instructions, which talked about no conscious intent to harm, not gross or flagrant negligence. So I think that this was a verdict where the jury read the instructions carefully and decided that the higher charge simply was not proven.
Sam, let me pick your brain a little more, because we had sort of a dramatic moment in there of the judge revoking her bond, remanding her. She's handcuffed. If, in fact, this is a second-degree misdemeanor under traffic laws in Florida and it's up to 60 days, do you think he was sending a message with that move, or is that typical for a case like this?
Absolutely, he's sending a message. Most of the time in a misdemeanor sentencing, a judge wouldn't consider keeping the person in jail pending sentencing. So I think the judge, for whatever reason, maybe he disagreed with the verdict, maybe he wanted the community to understand that when something like this happens to a child, there are going to be serious consequences. And it's hard to say why he did what he did, but I would imagine he wanted the community to see her put into custody immediately after being found guilty.
I want to add a bit of information, because we are trying to learn about how long it may be, how much she may face. There is a possibility that because of the great bodily injury, that this could be something that's punishable of up to 5 years. We will see. We'll get you the clarification on that. But Cody, what I want to ask you about is this mom. We saw her testify in court. We saw her sitting there in court. Just what are you imagining she must be going through right now, having gone the distance for the prosecution, and to see that top count come back as not guilty?
I can't even imagine the rush and flood of emotions she's feeling. 2 children lost under your own mother's watch, and now you're not guilty of aggravated manslaughter. It's just, I can't imagine. I can't even put it into words what she must be feeling, because let alone you've lost your mom for however long it's going to be once that sentencing comes. But at the end of the day, as you just mentioned a couple minutes ago, these are 2 children that are gone and are never coming back, whether there was a mistake or not. You know, so mistakes have consequences, and of course consequences will be brought, but that doesn't mean those consequences will bring either of those children back. And I know that's something she is thinking about every day, every night, for the rest of her life, her and her husband, the ripple effect that this will have, and let alone all of this happen under your own mother's watch.
Absolutely.
It must be incredibly saddening.
This is a heartbreaking one. This has tugged at heartstrings of so many people, not just for the loss of the life of this beautiful little girl and the loss of her brother before, but also that this is a grandmother. A lot of people thinking about their own time, spending time with their grandkids. And when we're discussing what could have come in, what may impact sentencing going forward, I want to take a look at an order that the judge made on the prior act, because typically, Sam, that's something that could aggravate sentencing, could be an aggravator. The court could find, let's say it's this third-degree felony that could be punishable up to 5 years. The judge could take into consideration something that was perhaps not taken into consideration before. But in looking back at the court file on this case, we have this in an order from this same judge on that pond incident, where the court actually found that the defendant was asleep when her husband was the awake person taking care of Ezra. That was the brother of the victim in this case. And that the grandfather left without waking her up and didn't pass, in a way, that responsibility to her because she was asleep. So the court found that the state failed to prove by clear and convincing evidence that Tracey Nix was the party responsible for the incident and death of the 16-month-old infant. With that strong language, do you think the court is going to take into consideration or perhaps sentence her higher because of that other incident? Or is that, from what His Honor has said in the order, something that he's not going to consider at all?
I think he'll have to consider it. I think even though it's mitigated by the fact that somebody else apparently took over, quote unquote, for the care of the child, the primary responsibility was with Tracey Nix. And there was apparently some split responsibility there. But at sentencing, everything comes in. I mean, not everything, but almost everything comes in at sentencing, where we have a much narrower admissibility standard for guilt innocence. The sentencing hearing is more wide open. So I do believe he'll consider that incident in assessing the sentence.
All right, we are going to take a break, but we're going to keep talking about this case. In particular, there were some things that happened during deliberation that the jury didn't even know about it. 3 experts on the stand and what they had to say about what could have impacted this grandmother's forgetfulness. More of this Tracey Nix case after this.
The people.
We, the jury, find as follows as to count 1 of the charge. The defendant, Tracey Howard Nix, is not guilty. We, the jury, find as follows as to count 2 of the charge. The defendant, Tracey Howard Nix, is guilty of leaving a child in a motor vehicle in excess of 15 minutes, causing great bodily harm.
Split verdict by the jury happening in Polk County, Florida this hour. We're following that breaking news in the Forgetful grandmother manslaughter trial. The jury acquitting her of aggravated manslaughter, but finding her guilty of the lesser charge of leaving a child in the car for more than 15 minutes. This is a heartbreaking case, one where a grandmother who had her child, her grandchild, 7 months old, in the car and forgot her there for hours. 90-degree weather there in South Florida. And it wasn't the first time that a child in her care had died. Surprisingly, shockingly, a year before that, her other grandchild from the same child was left in her care. She was asleep inside of the home when that child wandered off and drowned in a pond. Now, this jury did not know about that other incident. The judge said that there wasn't enough evidence to show that she was responsible in that one, and she didn't face charges. But after the second one, they decided, as far as the prosecution, to bring those charges and that top count of aggravated manslaughter, because they said that she should be held responsible for it. The jury saying not for aggravated manslaughter, but for the lesser charge. Now, something interesting happened during that 2-hour deliberation. There were 3 defense experts who were not permitted to testify. One of those was an expert in forgotten baby syndrome, Dr. David Diamond. And the defense, because they weren't able to get their doctors in on the stand in front of the jury, asked for those experts to come in and proffer their testimony for a potential appeal if there was a conviction, which there now has been. So let's look back at Dr. Diamond's proffered testimony, again, outside the presence of the jury.
I apologize, Dr. Diamond. I misheard something.
So what I do as a part of my research is to monitor the number of children, and the way I do this also is that I'm on task forces that keep track of children that are forgotten and die in cars. I'm on a task force in Florida because of the heat we have in Florida. We have a very high percentage of children that die in hot cars. I'm also on a task force in Texas where they have children, a very high percentage, but actually almost every state in the country, children have died in hot cars. I'm also on an international task force funded by the United Nations because children have died in hot cars all around the world. So we're looking to combat this epidemic of children dying in hot cars.
Have you been published?
So I have an online article in which I have described the neurobiology of what is going on when children are forgotten in cars. And this is a result of the way I do the research. So I personally interview dozens of parents, caretakers, and grandparents that have forgotten children in cars. I read the literature, I read the media reports as to what is going on, as to what is happening when a person is forgotten, when a child is forgotten in cars. So initially, I wrote an online article to explain this, which is an academic online journal called The Conversation. And that article has had over 150,000 views. I then evaluated the literature, the neuroscience.
Okay, everyone have a seat. You keep going, but we have...
And what happened during that time was the jury came back with a verdict before Dr. Diamond could even put all of his testimony on the record. But we wanted you to hear it because it's so important to this case and likely will be important to an appeal. We did get word from on the ground there in Polk County, Florida, from the defense attorney confirming to Court TV that what she was found guilty of, that leaving a child in a car for more than 15 minutes is a third-degree felony because of that great bodily injury that occurred, and it's up to 5 years that Tracey Nix, who is 67 years old, is facing once she goes to sentencing. Let's bring back in our guest to discuss this case. Criminal defense attorney Sam Bassett is with us remotely, and field reporter Cody Thomas is here in studio with us as well, just reacting to this case. Sam Bassett, let's talk about Dr. Diamond on the stand, not in front of the jury. They didn't hear him. Do you think if they knew more about forgotten baby syndrome and what he didn't get to, but I know because I'm familiar with his work, that he says when a person is out of their normal routine, like this grandmother who didn't typically take care of her child, that's when these forgetful things happen?
Yeah, I think that this is another example of maybe guilt-innocence evidence versus sentencing evidence. I think under the rules of evidence 702, the judge has a gatekeeping function on whether or not experts can testify, both in terms of the reliability of the evidence and whether or not it will help the finder of fact, in this case the jury, reach a decision if there's relevant use for the testimony. I think this judge decided no, that there wasn't enough to assist the jury in finding guilt or innocence, and he kept it out. So the defense did what they had to do, is to put his testimony on the record as much as they could to establish the record for an appeal on that issue.
Yeah, absolutely. Cody, I want to ask you about just the way that we've covered this case. I know when I first heard the headline that there was a grandmother who a baby died in her care, and because another baby had died in her care, they now were filing charges. I initially thought the police thought that this was intentional, and we found out it was a very different situation. But what was your reaction to just hearing the bits and pieces of information initially about this case?
I had a similar feeling as well, Julia, because it seems like a pattern. You have two children, two of your grandchildren in less than a year. That doesn't happen. Rarely do you see something like that happening. And on the top of what you were just saying, routine. It's understood that you could forget some things. You know, if you leave your groceries in the car, you leave a water bottle in the car, let alone a human life in the back seat. Even if you did, you might go inside, you might wash dishes, in her case, play piano and talk to her dogs for a few minutes. But it seems as if there should be something that clicks. Oh, where's my grandchild? Oh, where's seven-month-old Uriel? Let me go check. But obviously, that didn't happen, and of course, the tragedy happened in Uriel's death. But I did have that feeling of there was intentionality there. Of course, we found out it was not that, but here we are today.
Absolutely. Sam, final question for you. Do you think she should have taken the stand?
Oh, that's a real tough one. Usually, in most criminal trials, the defendants do not take the stand, in my experience, and that's usually a wise judgment. In this case, I think it was probably the smart thing to do, especially in light of what we've seen the jury conclude with the verdict. If she takes the stand, she runs the huge risk of what we call opening the door to the prior incident. If she were to make some sort of global statement that I always take good care of children or something like that, then bam, all of a sudden the jury gets to hear about the prior death. So I think it was the wise choice that she not testify.
That is a tough call. And Sam, I like that you brought out that she could have opened the door and it would have been difficult to stay on task, but you kind of wish the jury got to hear her explanation of what happened. But clearly they did not think that it was aggravated manslaughter, so this is a win of sorts for this defense. Sam Bassett and Cody Thomas, thank you for weighing in on that.